Same thing is referred 49,
Yes,
50.
yes. That's why I didn't. That's my
Yes,
39
and
to
the harda
46.
and all these cases.
Yes. The other judgment minutes is paragraph 46. That is on director and managing director. 2022 10 SCC 152. Para 46.
Para 46.
46 minutes. Again on.
That is the role of
And
director.
on cognizance, to determine the complaint has to speak for the role of the director or the managing director, and while taking cognizance, specific reasons are required.
Para number?
46 minutes.
46.
Minutes.
Okay. As a matter of course, he cannot be
Yes.
summoned as an accused. The order must show the application of mind.
Minutes. Yes. So,
This is relying on Pepsi foods.
and I
Yes. 46.
last judgment which my friend referred to Atamjit Singh. But this is against a conviction minutes after full-fledged trial. Is a revision filed against conviction minutes, and the facts in this case cannot be read into one,
Which judgment is that?
Referred by my friend Ravinder Malats, Atamjit Singh. It is 2024 SEC. 2024 SEC online, Supreme Court 99. And also the other judgment was Sanjeev Tari, 2025 SEC online SC 2069. There are two judgments which my friend referred. Both mallards arise from after full-fledged trial. But here I am in a, before your lordships in a 482 jurisdiction where I am raising a legal plea to invoke the inherent powers of this honorable court for quashment of the CC.
Here, conviction.
My respectful submission, Lord, these observations in light of a trial will not have any bearing to the current case. Lastly, my lords, learned single judge, while disposing of the writ petitions, my lord, gives reference to Bhushan Kumar. Bhushan Kumar is of the rendered in 2012. Learned judge was of the opinion that was holding the field by then.
What are the principle laid down in Bhushan Kumar?
Bhushan Kumar, para 20 and 21 minutes that discharge powers are available. I'll pass on.
Bhushan Kumar in our High Court order. Followed. It is on page.
But Bhushan Kumar, my friend,
the order of a single
88
judge.
and 89.
88. Bhushan Kumar, they referred and
that is how I was sent to the trial. In fact, Bhushan Kumar is part of my friend's compilation. Okay. By the date Bhushan Kumar was pronounced minutes and the learned judge chose to follow that. The previous judgments of Adalat Prasad and Subramaniam Seturaman, no, the law in those two respective judgments will not hold the field because Bhushan Kumar overrides it. So the learned judge was of the opinion that when he was rendering his this order in the year 2022 or 2022, order dated 20th December 2022, that Bhushan Kumar was holding the field. But by the said date, what holds the field is the constitutional bench ruling in the in re expeditious trial of 138 cases, where clearly, my lords, the parameters were laid down and specific directions that the magistrates are devoid, which is the language employed by the learned trial court. Matter was carried, all the contentions were left open. It was open to me to raise it in any form at any stage. Matter was carried to the Honorable Supreme Court. Honorable Supreme Court also sends me to the learned trial court. Supreme Court bench of 2. My lord, with all due respect, allow me to kindly permit me to put it to the form of submission. It's that order would be per incurium because it's not good law. Good law is a constitutional bench judgment which all of us are bound by. So therefore, my lords, I have to come back before this court in this petition, and I pray and seek, my lords, that this is a fit case where the petitioners role is not averred and no specific allegation is made. And thus, my lords, I pray
The
that
main
this honorable
contention
court-
is petitioner's averment.
Well,
Is
no
not
specific
averment, no
averment and
specific
allegation.
role.
That he is a managing director of a company involved in its day-to-day affairs and is entrusted with the affairs of the company is absent.
As per the
Totally
language in 254.
254.
2 subsection 54 sub.
Lastly, Manoj, I'm highly grateful for the patient hearing, and particularly this, if I may just take a minute more. When I entered the bar, Manoj, His Lordship Justice Subhash Reddy Garu was in the court. Very kind judge, a judge who often gave the youngsters an opportunity to appear. So thereafter, Manoj, this courtroom was succeeded by His Lordship Justice Sitaramurthy. I'm so certain, Manoj, your Lordship would also agree with me that
Yes,
the
it's
same
in the very
pattern.
same courtroom.
So, Milord, the vastu of this court, I'm highly grateful.
Vastu of the advocates also.
No, Milord, I
That
would
is
say
there.
this courtroom.
That is there.
No,
We all believe that.
Milord,
That's
No, no, because vastu of advocates also should be there, not only judges.
No, our horoscope.
This
No,
is the
it's the
favorite.
horoscope of the advocates and vastu of the court.
Yes,
Milord.
yes, yes.
So this courtroom, Milord, sir,
No, no, you all have done very well.
I'm highly grateful
That's what
Milord,
was
for
the
the
youngsters
patient
are
hearing.
emerging with good arguments. That's what was passing in my mind.
Milord, sir, I'm highly grateful.
As I've seen you all in the corridors
Yes.
and the way you all are arguing. Keep it up.
But
Very
last,
good
Milord,
assistant.
there's no reply to reply, Milord, but my friend seems to be readying up.
I'm
for
not-
a
Now we
reply.
are going to sit here only.
No, but I'm not giving reply to reply. Not these three judgments which my friend is submitted today, not yesterday. That's the reason, not whatever my friend is submitted, I've given clarification. Now my friend today has given 3 to 4 judgments.
It's in reply to my friend, Milord. Naturally, I mean,
For that, Milord, this HDFC Bank judgment which I quoted, Milord, where Milord Ashok Shekhar Vamani and others quote, just now my friend.
Yeah, those are only precedents.
No, Milord, that's what, Milord, that the same was taken into consideration by the HDFC Bank judgment in the year 2025. Your Lordship may see page number, para number 31.
Which one? HDFC.
HDFC, Milord. Taken into consideration.
but
And it is
HDFC
decided
Bank is
that-
Para 5 is what I said, Milord, that there's a specific averment.
But
So
case to
therefore,
case, the fact is different and the same was
Yes,
considered.
yes.
Page number,
Well,
para number
it's also
31,
different. Para?
31, page 23, para number 31. This judgment gives an answer to all the 4 judgments. Milord. Got it, Milord? Para number 31.
Yes, yes.
Ashok Shekhar Man. Got it, Milord?
Yes, yes, just now he read all.
That's what, Milord. Just now my friend has
He read
said.
the judgment only.
Yes, Milord. Now your Lordship may, this has been taken into consideration.
and is saying, Milord, that was considered by this bench.
And as given, and my friend is saying that Milord, SP money cannot be hold good because of this judgment. This court, Milord, in the 2025, taken into consideration of this judgment, SP money judgment, your Lordship will find it para number 37. Para number 37.
Yes.
But recently, so and so judgment, 2 judgments were taken into consideration. KK Hauja and the paragraph which was the same paragraph which was extracted in the present judgment and come to a conclusion which is at para number 38.
Yes.
But only one paragraph. Has rightly held that administrative role of each director would be within the special knowledge of the company or the directors from the firm. It is for them to establish that they were not in charge of the affairs of the company. In view of this contention, the learned counsel for the respondent to the specific role of the attributed to the director should be set out of the complaint. Does not mere acceptance. Reliance has been national small industry and about to the 39 paragraph, Milord, which was a given answer taking into consideration of SP money, KK Hauja.
But
brings-
in the present case, who was the petitioner there?
A2, Milord, who is
No,
the
no, in this case, I'm asking.
Para 5. Para 5. That's where I requested para 5.
accused 2 to 4 are the directors of the accused number 1.
There's a clear assertion to that effect, which is absent in my case.
And is responsible for its day-to-day affairs.
Yes, Milord.
They say so.
Management working of.
That is why, my lord, the court went to
Furthermore,
the-
the accused number 3 signatory of zones.
Even this is absent in my case. That's
In the
What he
case,
says that they are responsible
that is what, my lord, that is the answer given by
for
his-
his day-to-day in view of the said
That-
facts
that's
and
what- that's what,
circumstances.
Lord.
This law was
That-
laid
that-
out.
that-
So finally, they said that it is for them to prove.
Yes.
No,
But
that,
this is
that,
against
that, that is the
section
reason,
is
Lord, SP money, which categorically says in each and every paragraph, and also in this judgment, HDFC Bank judgment, where you failed to reply properly, saying that, Lord, I am
You
no way.
not understanding. Here, the what was decided is they are responsible in
That's
day-to-day
what-
affairs. But
that's
in
what.
his case, there is no such awareness.
That is what, Lord, I would like to submit.
And
In
if
my
the-
case, Lord, I said so, saying that 2 to 4 are the persons who availed the loan, issued a check, and the same as.
Okay, okay. And one more aspect, according to him, 234 and 254, they should be entrusted through some resolution or whatever it is. Though he is accepting, he is a director. He
That
is
is not the law.
entrusted. Is entrusted with the day-to-day.
That is not the law, my lord. So that's in a SM pharmaceutical
not
case.
the law.
That in a certain pharmaceutical
No,
case,
no, but if that is not the law, if the definition is not fitting into, how is he liable under 141
that's what,
vicarious
Lord.
liability?
In SM pharmaceutical case where I read out just now, even the person who is responsible for that, even that person can be tried. SM pharmaceutical.
Paragraphs may be referred to, we need not again repeat it.
That's the reason, Lord.
Follow. One
We have,
sentence is there. in,
Yes, Lord,
some
specific-
paragraph.
Though, enough energies
Though,
for
no,
active
there was one sentence saying, though not directors.
Yes, those
Yes.
are directors.
That's
You're
what
also-
I really like.
So 234 is absent, 254 is also absent.
Yesterday, my friend has read,
Section
my
2
lord,
subclause
4 lines,
34
and thereafter,
54.
not even a non-director can be liable under Section 141 Act. Full stop. The averments in the complaint would also serve the purpose that the person sought to be made liable would know what is the case which is alleged against him. If it is knows that, my lord, the day-to-day transaction, he is responsible, my lord, he is liable for prosecution. These all things, my lord, he need to establish and prove innocence in the trial, not before this honorable
No, I
court.
think that is only SMS pharmaceutical.
That's what, my lord.
Where she was involved, that lady.
Yes. Neeta Bala.
Yesterday, yes. Neeta Bala.
And another judgment, my lord, which my friend has read, the 3 judgments.
It's very interesting academic because
Yes.
I'm also interested to know if you keep on telling these will be just hearing advocates here. Huh?
But the JM Laboratories case will not come in the way because it's under Drugs and Cosmetics Act. And my friend has quoted 2 judgments where way back in the year 2022. The Sarabjit case, where I, 2025,
That's against,
25,
After conviction.
That's
25,
against,
Lord, but that's the reason, Lord, I trouble your lordship, saying that, Lord, the guidelines were framed how to conduct the trial of the STC cases, and the guidelines, Lord, your lordship, I am permitted to only show.
Again, STC cases, again he gave some judgment.
That's
with
what,
regard
Lord,
to
that those will not come in my ways. That's the reason, Lord, I relied upon the judgment in the year 2025. Son of JB. This is the latest law as on today. Para number 35, my lord.
Para number 30.
Para number 35.
But I'm not stepping into that argument of conversion. I'm only.
It is not about the conversion, my lord. What are the steps need to be done by the magistrate? He is referred, my lord, in this case. But 35, para number 35, your lordship got it.
Yes.
Admittedly, the offence under Section NI Act is quasi-criminal in character and is compoundable, so and so. Now, your lordship may see para number 36. That quasi-criminal in nature is my point to submit, my lord. Now, your lordship may turn to next page, my lord.
Yes.
This is the procedure, my lord. Complaint, how the complaint should be filed and what is the material should be added. Now, your lordship may turn to, come to E, my lord, which I read over.
Yes.
Now, next page, your lordship may turn. But for sake, my lord, your lordship may, I'm permitted to read F because it's continuation. Since the object of 143 NI Act is quick disposal of the complaint under Section 138 by following the procedure prescribed for summary trial, your lordship got it, my lord?
Yes.
Summary trial under this court. This court reiterates the direction of this court in so and so expeditious trial case. Court shall record cogent and sufficient reason before converting the summary trial to summon trial. To facilitate this process, this court clarifies that in view of this judgment, Delhi High Court line, the trial court shall be at liberty to ask the question in deems appropriate under section 251, 274 BNS, including the following questions. Do you admit the check belonged to your client, your account? Do you admit, did you so and so? This is the inquiry they need to
But
conduct.
what is the law? Court shall record cogent and sufficient reason.
That's what
before
your lordship,
converting
your lordship, at the time of converting,
converting, not required.
Not
The
required, that's what
summary
we learned.
trial is your content.
these 4 questions is enough. It is a domain of discretion of the learned magistrate, my lord. G. The court shall record response to the questions in the order sheet, presence of the accused and judicial counsel. Thereafter, determine whether the case is fit to write summary trial under chapter and BNS.